got my approval now one time. You never even offered me a dime. And I'd be on the phone telling the bank that in a heartbeat. I'll say, first of all, you done stole my client identity. And you took the loan and you sold it on Wall Street. You didn't even offer them a dollar. So how can you sit up here and say what they owe you when you, in reality, you really owe them? We don't owe the bank anything. The house is ours. They don't even want the house. The house is just something that they gave us to satisfy us, so they can do what they really need to do. Because without that signature of ours, they couldn't make a move. And believe it or not, the promissory note. If the promissory note, and you see you got a promissory note, and then you see it say pay to the recourse, and you don't see nobody's name on it, well, literally, you as the homeowner can sign off on it, because it's just a blank check and anybody can sign on it. Anybody can sign off on that loan. And you'd be surprised when you go to court, the judge got a part of it. The attorneys are also your investors. And this is even the sad part. The investors, the banks, allow their employees to also become investors. So wait a minute, now you invade my privacy. Now you invade my privacy, because identity theft is invasion of privacy. Because you took everything away from me, everything. You didn't leave me anything, and you traded this. You traded all my personal information. We got the privacy obligation here, non-public information, all this stuff. All this stuff is what I brings to their attention. And I'm coming heavy with this. I'm saying you stole my identity up under the U.S. Patriot Act. Can't get no stronger than that. Because when you file for identity theft, you go up under the Federal Trade Commission. Where we do, as consumers, we do have our own separate laws for identity theft. The U.S. Patriot Act was designed for the banks, all the financial institutions. That was designed strictly for them. But what I'm doing is, and what I have done, is I took that very same act that applies to them, and I just flipped it right back on. I said, okay, well, wait a minute, this is for... Now, if I came up to the bank, and I'm using Barbara's name and address and telephone number and her social security number, and I'm trying to get a loan for you, and you grant that loan, and you knew that I just committed a serious crime right here, now you finna come after me because I just committed fraud in your bank. So now you can claim that I stole somebody's identity. Same thing applies to the bank. Same thing. So therefore, up under that U.S. Patriot Act, they cannot back down from it. They don't know how to defend it, because they have to figure out, how did this homeowner ever even thought about that? Because I'm gonna tell you now, if you look it up on the internet, that is one act that is really hard to find if you just want to read the act yourself. Took me 3 days. And then I finally, after the third day, I said, you know what, I just give it, because all I'm seeing is a bunch of hearsay. I don't really go by blogs on these internets, because I can't deal with hearsay. I need pure facts. In order to protect my clients, I got to have facts. So I just gave up on like the 6 or 7 day, 2 o'clock in the morning, someone said, wake up. Go pull up the U.S. Patriot Act. The moment I hit it on, there it was right there. U.S. Patriot Act, the act itself. And I sit there and I read that thing. And when I seen what that thing was, how that act was designed, I'm like, oh my goodness, I just got you. I just got you big time. That was the best thing that could happen to me after 10 years. That was the best thing. Lord knows that was the best thing. Because I knew it was something out there that I was really missing. I just couldn't put my fingers on it. I also knew it was a straw buyer, but I couldn't find him. Now I know exactly where he lived at. Now I'm finna go and get him. You see, I done already had a few banks and a lot of attorneys out here. They know me very well. My name right now is going through the attorney network. They making fun of me. That's Sonia Davis. I'm telling you, I better be careful with her, because she thinks she know it all. Well, now they really can say that, because now I do know it all. Because I sent the word, because I sent the word to them. I say, I told you I was coming back on you. So you made a laugh at me then, but I guarantee you before it's over with, I'm going to have that laugh. Because now the fat lady finna get ready to come on this stage, and she finna give their final performance. And that's what's going to get your homes back, and then some. Okay, I want to use a couple of samples real quick, and then I got a surprise for everybody. First thing I knew before, when I first started, whenever I find something new, I got to test it right away to see how well it's going to hit the market. Where I put my affidavit of commerce, moment I found out about it, I went out there and I started pushing it out there. And I found out how everybody was responding to it. The more I wrote, the better I got. Okay, some things I still had, I was still in the learning process, but I was still writing them out anyway. First time we went to the court, I said, I got to be in that courtroom. I got to be in that courtroom. And the judges didn't know what to do with it. They was very confused because no one had never brought anything to their attention like that. All you got to do is take one piece or file one motion that the judges are not used to getting on their desk. They're going to go back and tell all their colleagues, oh, let me tell you about this, what I just got. And be on alert because this is coming from, this is probably going to start flooding the 28th floor. Now, a lot of the older judges are still sitting on the bench like Judge Cinco. That's what I call him. Does anybody get him? He's one of my favorites. In other words, we can't stand each other. I go in this courtroom now just to intimidate him because he done already done. We and him done had a lot of arguments, about these cases. So when it went, the first time it went, the attorney literally told my client, you know what, I can't do this. I have no way to defend this. Whoever put this together for you guys, they knew exactly what they was doing. You guys got a good case here, and I advise you to take it and move forward with it. But right now, that client's sitting up in federal court, and they are right now is getting ready to have a nice settlement out of this. Second time, we went in court. The judge like, I just don't know. I just, and the attorney like, well, I don't know what to do with this. Third time, I went into court. This was the most special day. But I'm only going to talk a little bit about this because I got a surprise for you. We're going to probably say a little bit more. We went on a Friday. Most judges don't even have court dates on Fridays. That's their day that they have to sit back and read everybody's complaint. Judges, when they get their complaint, they only read the first page. They never sit down and take the time out to read the whole motion because they don't have that kind of time. And anytime a judge sit down and read your whole motion and you hit on something on that very first page that got their attention, then they going to take the time out to read. Because I actually have judges to stop the court right there in the middle of the courtroom and say, let me read this. And then they had to say, wait a minute, I'm reading on the computer. Let me put the computer down because my eyes is getting bad. I want to make sure I'm reading what I'm reading. Then they picked up the paper. Then they said, you know what, I'm still not sure. Let me read this on my computer again. It was so quiet in the courtroom you could have heard a pin drop on the rug. This is when you know that whatever you're doing, you head in the right direction, whether it get approved or not. But you stepped on some toes. This particular day, we're waiting, and the bailiff come and say, what y'all doing here? Ain't no court today. I'm trying to figure out why ain't nobody else there but us. And so she said, well, since you're here, let me go see if the judge will hear your case. This is when I knew God that came into that courtroom. When the clerk came back and said, the judge said she wanted to hear y'all case. I knew then, I'm finna get ready to watch a miracle unfold. I knew then. And I seen that miracle unfold right there in that courtroom. Circuit court, daily sitting 28th floor, unheard of. Unheard of. So, what I want to do is, if she don't mind, I want to bring up that young lady who was there that day. And I want her to tell you in her own words what happened. Sister Melinda Ellis, Could you please come and share your testimony with our guests?
Can I do it from here?
Yes,
No, I
ma'am.
want to put you on the camera.
Hello, everybody. And what Sonia's saying is absolutely true. We did our paperwork. We filed our motion. I believe it was the motion to be heard. We sent the judge a copy, but somehow she didn't receive it. But now I guess as we were going through this process, the thing that we learned is when you send something, you send it certified mail, so that you always have a receipt that not only did you send it, but that they received it. So I didn't take all of my paperwork to court that day, but I did have that. And so I was able to give her the green card saying, we sent it to you and somebody signed for it, saying that it's okay for us to have our court date on Friday. But yeah, it was interesting. She heard us, we gave our paperwork to her, and we met Sonia in September of last year. We had gone through we had started the foreclosure process. We had been in communication with Bank of America for 2 years. We started with someone else. And so we were sending our paperwork back and forth, back and forth. So for a year, almost a year and a half, we were back and forth with Bank of America. And they hadn't filed bankruptcy, but then they gave us the intent to foreclose, which once we didn't know it was an intent to foreclose, because it wasn't until we got with Sonia that letter stating that it was an intent to foreclose was buried on like the 3rd or 4th page. So we didn't really know it until Sonia pointed it out to us. But we were lucky enough that we were within that 30 days. And so right away, Sonia put together an affidavit of commerce for us. And we sent it to the bank so that when we got to court, we were able to prove that yes. No, first, because she wouldn't let Sonia speak, so we were on our own. But we pointed out that we had 30 days to respond based on the fair debt and fair debt. And she said, well, you only have 30 days if you submit it in writing. Well, we did, and here's our proof. And so we gave it to her. She wanted a receipt that we sent it to the bank. We gave that to her. And she said, well, you don't have to come back and see me. I'll send you my verdict in the mail. And we're like, we don't have to come back? No, you don't have to come back. I'll send you. And Sonia was positive the whole time because the judge saw us when she wasn't supposed to. And Sonia was just really positive. We didn't know what was going on. But sure enough, we got a letter in the mail in January saying that they had granted our motion to dismiss the foreclosure that Bank of America had filed because they didn't allow us our 30 days. But in the midst of all this, they also sold the mortgage. They sold the mortgage, they changed the servicer. So Bank of America is no longer in the picture, but they've dismissed their foreclosure. So we're not done yet. Now we've got to go after the next people. But Sonia knows her stuff. Sonia knows her stuff, and she really, did it for us. That affidavit of commerce was just unbelievable. So it does work.
One of the main highlights about that day, because the clerk told us, she said this particular judge do not hear motions on Fridays. And she was nice. She said, well, if these people came, I'm going to hear their motion. I'm going to hear them. So then they had to go and call the attorney. Say, look, y'all better get your bus down here because y'all going to hear this case. So he came on and we went in, it was just us. And one of the things is that really grabbed me because I'm always watching the expressions on people's face, the judge and the attorney. He had that affidavit in his hand. And the judge said, okay, well, what you want to do with this motion? And you're like, motion? He's like, I ain't worried about no motion. I want to know what to do with this. Now, he's waving up this, like this, just like this to her. And she's like, what is that? He said, it's affidavit. What am I supposed to do with this? Don't think I started jumping into my seat. Because I knew then my affidavit was having a big effect on the attorney. And she like, what is that? Let me see that. I'm talking about this. And then that's when she asked Miss Ellis, well, did I get a copy? She said, yeah, I sent you one. And she said, well, you can have my copy. No, so she said, so the attorney like, well, you can have mine. She said, well, I got to read this. I want to read this. And he studied, said, but what am I supposed to do with this? What am I supposed to do with this? And she looking at it like, she said, She said, I want to see this myself. So she asked Miss Melinda, she said, well, yeah, I can see that somebody got the copy, but I need you to send this out. So no, go down and send her number. But when she told Miss Ellis, when she said, well, you ain't got to worry about seeing me again, I knew then we had just won our case. Because in reality, when she told her, I just granted you that summary judgment, and I'm finna have this case vacated. This is unheard of in circuit court on the foreclosure case. 1 out of 1,000,000, seriously. And I've been going up there for 10 years. No one has ever got their case dismissed. I only know one other person, and the only reason why he got his dismissed because of improper serve. Other than that, no one ever got their case dismissed within the first 30, 45 days of being served a foreclosure case. Nobody. She dismissed it without prejudice, which is fine. I told long as we got it dismissed. But when she read that affidavit, she was just too outdone. And I wasn't even worried about nothing after that. I said, girl, ain't nothing to worry about that. We got them. We got them. So now, I'm talking to Wells Fargo. And see, one thing about me, I make sure I get my point across. I'm going to always have the last word when I'm talking to these banks. So I'm going to make this, then we're going to take the questions. I'm talking to Wells Fargo, and I'm talking on behalf of one of my clients. No, first of all, I don't want to jump the gun here. I want to mention one more quick thing before we go in here. Because one of the things that goes with the fraud and identity theft and invasion of privacy is the RICO law. The RICO law. Now, up under the RICO law, we know what this is. Well, when they actually trading paper for money or either gold or silver, I call it gold, silver, and currency, they are actually committing money laundering. Okay, money laundering, it falls up under the RICO law, is also part of racketeering. But I don't use racketeering because I don't have enough evidence to show that they are really doing any kind of racketeering, because it's the way everything is set up. You can't really classify that as racketeering. But what you can classify is that the fact is that you trade paper, which is counterfeit money, and you trade it in for real money. This is called money laundering. And that's what all this stuff falls up under. At the end of the day, they still falls right up under this law. This act right here comes with $1 million damage fees, which is one of the things that if you go into a courtroom and the judge go ahead on the rule on this, where you say, no, you know, money laundering is $1 million damages within itself. You know, so that is a starting point for anybody who want to file a lawsuit. Okay, so now the other part of this fraud also goes into mail and wire fraud. You can't have one without the other, because one of the things they do, they mail the application, the bonds, to whoever they're going to send it to. And in return, they wire them the money into some account. Now, the straw buyers, a lot of times they are the person who actually originated the loan, is the depositor. And Wells Fargo actually holds most of these certificates within this special federal savings bank. Then that's what they do. Then they go ahead on and once they get the money, then they go ahead on and wire it to whoever account that it's supposed to be into. So when I get ready to put my stuff together on your behalf, I'm using all this I'm not leaving anything out, nothing. Because I want the bank to know, we know what time of day it is now. We know how you took us when we sit at the close table. We know what you did with our loans. I know exactly how much money you made off of me. I know exactly now how my loan was classified. Now I have what they call proper cause of action to bring forth any kind of legal action against you for fraud. So if anybody want to know where your fraud at, well, you just found it. So now you go back and say, oh yeah, fraud, yeah, I know, yeah, they don't fraud me. So now it's not no fraud, well, I don't know where the fraud is at. Now you know exactly where the fraud, how the fraud took place, and where it's at in your documents. So my advice to you, please read your mortgage contract. So you can highlight all, because their mortgage contract is full of breaches. I only pointed out 2. But the whole mortgage contract is a breach. And the breach of contract is actually in a category of its own. And I call it a misuse of mortgage identity. And I put this all together in an affidavit of commerce. See, with just an affidavit, they're not even gonna pick it up. They just gonna toss it to the side. But once you go back and put it in the affidavit of commerce, what you're basically doing is you telling the truth and nothing but the truth. So now they gotta pay attention to that. I got clients who had lost their homes way back in 2006. And they just start sending this stuff into the bank. And now the bank is like, oh my goodness, they finally realized what had happened to them. And now that she getting a good response to what is that she doing. There it is. Commerce, the foundational law of commerce assists in the telling of the truth and nothing but the truth. And that's what we're doing in the affidavit. That's why the attorneys, they don't know what to do with it. The judges, they don't know what to do with it. Matter of fact, we had, my clients has just launched a class action lawsuit against Wells Fargo for the whole state of Illinois. So if you have a Wells Fargo account and you want to be a part of that class, please see me so I can go ahead on and make sure that you get signed up. Because the attorneys, what they're trying to do right now, they're trying to get the case dismissed. That's not going to happen. That is not going to happen. You know, because they only send the signals out to the parties who filed the class action. But they forgetting about the other class members. And other class members is you. I do also have 2 other clients that wants to also file a class action lawsuit against Bank of America and Nation Star. In case anybody got Nation Star, you know somebody who got Nation Star account, we also finna file one against them. And see, one of the things is Nation Star is just a servicer. A lot of your mortgage companies say they just servicer. So when you send them that affidavit and they reply to you, then they gonna say, we were just a servicer, we didn't have anything to do with it. But no, but once you got the power of attorney over that mortgage contract, that made you obligated. So the investor already to inform you, whatever you decide to do with this loan, that's what goes. Now I got this information straight from one of the certificate back holders when they had called me and told me, Ms. Davis, I'm telling you now, we gave them power of attorney, so you need to go, you need to go back, talk to the service and tell them that we had sent you to them and tell them to go ahead on and get that solution deed. And I said, well, you know what, you can put it any way you want to put it. But then you think that's going to get you off the hook, guess what? It's not. Because we coming after you too. Because you was the main ones who took our name and our information and you gave it away without even asking for our approval. So don't think that that's going to get you off the hook. Oh, I tell them in a minute. I do not bite my tongue when I'm talking to the mortgagees, when I'm talking to any of these authorities. Right now I got the FDIC working with us. They just launched a full investigation into a lot of these loans. Everything that I do, guess where it's all going? Your affidavit is not going to only one local agent out here. Now they twist my arm to me. When you get ready to send the Department of Justice a complaint, make sure you send it to the one downtown. But they're just for folks out here in Chicago. Everybody else is going back to Washington. So your affidavit is not only gonna go to the bank or the servicer, it's going to whoever originated the loan, whether they're in business or not. It's going to whoever's the certificate holder, the depositor, the sponsor. It's going to the Department of Justice. It's going to the Controller of Currency. It's going to the White House. It's also going to HUD in D.C. And it's also going to the Controller of Currency. And it's also going to the Inspector General's office. So you're going to be sending that out. You're going to be sending that to like 7 to 8 different entities. And that's what we're doing, is we're inventing a paper trail. So when we get ready to go to federal court, the judge is going to see, when they look at that affidavit, they'll say, wow, did you really send that to everybody on this list? Here's the receipts right here. Here's the correspondence I got from some of these agencies right here. So the judge is going to know how I'm going to get around there, because 9 out of 10, the judge is one of the investors as well. And can't nobody demand no jury trial, because we're not going to find no partial jury. Because everybody out here, either they're homeowners, they own some kind of real estate, or they know somebody who got real estate, and the bank is treat them like straight up animals, worse than animals. So you're not going to be able to find no partial juror to even take on a case if the bank demands for a jury trial. So they're only leaving one position, and that's the settle. That's the settle. Because we can prove that they stole our identity from us, but they cannot prove that they didn't. That's the sweet thing about this whole case. I can prove that you can, but can you prove that you didn't? Okay, and this is one of the things that's what's making the Real Fresh Start finna turn this whole entire system and take it all the way into a whole new level. Forget about the promissory note. The promissory note gonna come with it. Okay, the problem, like I said earlier, the promissory note is the weakest link. It's all about the identity theft. That's what it's all about. So at this time, we're gonna go ahead on and take any questions anybody have.
Make sure that you understand this one.
This right here, basically,
This is just some information
yeah,
you guys should
so
know.
we're gonna leave this on the screen. Anybody wanna basically come up here and read this, but I'm gonna take some, we're really pressed for time here. So if anybody have any questions, yes ma'am.
My head hurt from that.
I know, I put a lot on you folks, I know I did.
Everything that you have talked about is basically in this bag right here. I've been going pro se with J.P. Morgan since about 2009. Even to the affidavit of commerce. And when the judge got the affidavit of commerce, to the point that the lawyers sent me like big stacks of documents to have, to answer. I answered everything. They didn't answer anything. Went to the judge, told the judge they didn't receive anything. I presented the return receipt. The judge ignored me, which is in my court records. Then he gave them an extension to answer. They still didn't answer anything. Then, when we got to the point, the day that we had to go, that they gave the summary judgment, I had the affidavit of commerce that I had filed. I filed it prior to going in. I handed it to the judge and I handed it to the attorney. The judge just looked at the first page and it was just like, this case is finna be over right now. And he did a summary judgment. He did a default on me. He did a motion to sell. He did everything that he could that day. And I have proof. When you said the 3 loans, my girlfriend, I'm always telling her, I said, Janice, they got 3 loans on me. And I got the proof because I was sending multiple correspondences to the different mortgage companies. One mortgage company sent me a LSAM history report, which showed me I got a audit The loan was simultaneously audited, the first loan. The second loan, they executed that loan 6 days after the securitization of the first loan. The loan that they're suing me on, that they're selling the house for, is that third loan, which I have correspondence from them saying that that was a system change loan. So I've kept all my records, this big old bag. When I talked to the gentleman today, he said, bring all of your stuff. I was like, no, I don't think you know, you don't want all of our stuff. He said, yeah, bring all of your stuff. So I brought most of my stuff, not all of my stuff, because I didn't bring the stuff about NACA or anything like that, because I went to them trying to get assistance first. And they told me, you need to put in a complaint with the controllers.
Yeah.
You know, so it's everything, I'm just listening to you and I'm like, oh my word.
See, you're on the right track. And I tell homeowners that you already did a whole lot of homework. You already on the right track, you only was missing on these. I said it took me 10 years, and it's been in front of my face from day one, when I started talking about the straw man. Because I knew that straw purchase was there, I knew it was. I just couldn't find it. And I knew eventually it was gonna come my way. I didn't have to keep looking for it, I knew eventually it was gonna come right to me. And that's exactly what happened, it came right to me. Now, only thing you was missing in that affidavit, the judge wouldn't say what you did, was the fact is about that identity theft was always a platform. But see, sometimes when you put out a lot of paperwork, you gotta make sure that you quote the right regulations, because sometimes the wrong regulations can turn everything in the wrong direction. You know, so when you go up under, especially for the promissory note, there's several laws out there that actually makes the UCC code even stronger. So you need to come with, and I come with all of them. The Information and Freedom Act, that actually boosts the UCC. I mean the UCC. I actually come in with the Negotiable Instrument Act, talks about the promissory note. Also go up under HUD. See, HUD has a law that also talks about the contract, how the mortgagee cannot defraud or breach their contract. I also use that. And when I put it, I put the paragraph in there into the affidavit. I just don't put a title in there. I put the title in there, yes ma'am.
There are also some things that they don't do. According to the state, they are supposed to notify the state that they're going to foreclose. The state is then supposed to notify the debtor. They never do that.
Okay.
They never do that. And not only that, they are supposed to prove that that debtor is a corporation.
Okay.
I got those laws at home. I neglected to bring those. I'm sorry.
Now, one thing about that, because then the reason why it don't come up in the circuit court, because there's no jurisdiction there. Okay, so they're not gonna, a lot of stuff you're not gonna hear in circuit court. Only thing that you're gonna hear them say is the Fair Debt Collection Act. And I had to challenge the judge that some years ago when the attorney got up and said, well, Your Honor, this is, we're here to collect the debt based on the Fair Debt Collection Act, and it was all in the paper. So I asked the judge to say, first of all, if he's here to talk about the Fair Debt Collection Act, and this court do not have jurisdiction over it because that's a federal law. So therefore, why my client over here cannot use that same law? Because first of all, they was calling her every hour on hour, harassing her, demanding payments and all this other stuff. And then they don't even have legal standing up under the same debt. So how can you sit up here and allow them to present that, and then you deny her the same right? The judge said, oops, you know what? You're right. You're right. Do not use that in my courtroom ever again. Even though they still use it.
They still use it.
But that particular day, that it was obsolete for that, just for that one day, because I was there. And he had to let the other attorneys, don't come up here and mention that particular law, because it's not going to happen. So, because it is a federal law. But see, when you get served, you have to put that on your summons when you get ready to respond to the summons. You have to do it within the first 30 days and saying that, you know, I moved this court to dismiss this case based on either personal jurisdiction or this court lacks jurisdiction based on the fact is that fraud was committed into this loan in the conversation. So when you filed it within the first 30 days, so now that it's all over with and you still got all your motions got denied, the judge done kick you out, now it's time to go file your appeal. That's when that same little piece of paper is gonna come back into the picture. Because if you start filing any kind of discoveries, like a lot of people like to file interrogatories, when you get ready to do those interrogatories and you did not file a plea with that answer, those interrogatories don't mean a thing. Because even the appellate judge is not going to overrule the circuit court. If you go into federal court and you're talking about a wrongful foreclosure, that judge is not going to overrule that circuit court judge ruling. Not for it to happen. Because the first thing they're going to throw at you is the Rockefeller doctrine when you get ready to go into federal court. It overrules any of the judge ruling because the judge can't overrule that. So therefore, if you're going to go that route, you're not going to use wrongful foreclosure. I don't even talk about wrongful foreclosure at this point no more. Because this ain't got nothing to do with foreclosure. This got to do with what you did to me when I first sat down at that close table. And then what they do is, when you send any kind of affidavit, any kind of request, and the first thing they're going to do, they're going to try to validate the debt. And I told them, they go, you know, first of all, I sent you an affidavit. I did not send a written qualified request up under the RESPA Act. So why in the heck you sending me this information when I didn't request it? So what I do is, I don't make it no better. I put the terminology of what affidavit is. As soon as I make that introduction, my next paragraph, this is the definition of affidavit. So don't confuse it. And I actually put that on my documents when I get ready to put them together. I say, so there won't be no misconfusion at all. Now, I want you to say that, because if I was going to ask for a validation of that, I would have been sending you something totally different, which is a notice to principal, or either a written qualified request, just saying, I want you to validate this debt. That don't have anything to do with it, but they going to send, I know it, like I told this attorney the other day. Well, Ms. Davis, we went on and validated the debt. I said, but first of all, I never said anything about validating the debt. And now I'm talking to this attorney, he's out in Washington. And he's like, well, Ms. Davis, we done did our part. I said, no, you haven't. I said, what about the other part of the affidavit, the main part? I'm talking about the fraud part. Well, hold on one second, hold on. And then now he's getting real nervous because he don't know what to tell me now. Well, I tell you what, why don't you call this other lawyer who's having the foreclosure? But I never said anything about foreclosure. So why are you talking about the foreclosure? No, Ms. Davis said, no. See, now I'm talking about this. I said, well, no, unfortunately, I'm going to have to inform my client that they need to seek out some kind of legal help. Oh, no, Ms. Davis, don't do that. No, but let's see if we can work this out. No, we can't. It's nothing to work out. You know, and then when I asked the bank the same thing, I asked the bank, I said, well, if, like I told this lady the other day, and she gonna say, well, we don't feel like we violated any laws. I said, well, according to the mortgage contract, it said you have to be in compliance with all federal and state regulations in Illinois. Well, we felt like we have not done anything wrong and we are in full compliance. I said, well, just give me one. I said, I can give you a whole list of the ones that you violate. Now just give me one that you're not violating. She couldn't even do that. She couldn't give me that one law. I said, well, I'm asking you again. Give me one law. Well, we don't have to give you anything because we sitting at home, we sending them a notice out today. Well, is there one law going to be in that notice? No, it don't have to be. I said, yes, it do too. In order for you to defend yourself, you better give me at least one. And she hung up the phone on me. So I know that I'm moving in the right direction here. When the lenders cannot come back and say anything or either even try to scrutinize what I done put out there to them. They cannot say a word. And I say, boy, you folks just don't know. Y'all just don't know what y'all just did. And a lot of times I have to tell them, you know what? If I were you, I'd be very careful who you're talking to. Because I really literally had them put me down. I've been blackballed by Bank of America. I've been blackballed by Chase. And I've been blackballed by Wells Fargo. We'll work with you, but we ain't work with that Sonya Davis. We ain't working with her. Unless you can put that in writing, don't tell my clients that. But I turn around, I tell my clients, son, you go ahead on. Because I want them to think that I'm out the picture. So I was on the phone talking to Wells Fargo, so I would tell like I was my client, right? And she gonna say, I know this is Sonya. You knew too much. Excuse me? Yeah, I know this you, Sonya. I'm like, baby, ain't never talked to you before, you know this me. They know my work.
Yeah, you knew too much.
Everybody knows, that's right, everybody knows my work. The judges know it, the attorneys know it, now the banks all know it. Now I'm getting notices from the government. So even if I don't put my name, because sometimes I have to just put the client name on the affidavit, don't even put my name on there so they can get it notarized without me being there. You know, but then the banks will call me and say, well, Ms. Day, we know this you. I got folks up in New York and Pennsylvania. And the bank called me, well, we know that was yours. You know, so everybody done got used to me now. Everybody done got used to me, so they know that if I send something in there, they know they're gonna have problems trying to object to it because there's no objections there. And this is nothing but an objective that we have to overcome, and now we done overcame that objective as you see here today. And that's why I felt like putting on an event like this, educating our homeowners, because I need for everybody in this country. Even we got all of them homeless folks out there who lost their homes. All of them fall victimized to this. So we need to make sure that we get the word out to our neighbors, our cousins, our relatives, everybody, our friends. Say, girl, y'all got to know. I'm telling y'all now, we got to do this, because this is the only way that the bank is going to give us our money back. The only way. And see, now, I was talking to a client yesterday, and he got a weird phone call. We watched it. I was like, so did you call no one back to see who it was? No, so we decided to call no one back. And it was some kind of advocacy group. And so when we looked the name of the advocacy group up, I said, wow, look at that. He right across the street from the White House. And see, my affidavits are going straight to the White House. And I'm like, why would they call you and talk about they were supposed to be on a conference call? How did they get you out of nowhere? You know, so I know this thing is making a huge impact. It's just a matter of time. It's just a matter of time, because now I got another gentleman. You got a question? Okay. Yes, sir.
Yeah, I'm pretty upset that they bailed out the banks in a hurry. 1 week. They're telling the public, I had 3 of them.
Okay.
Telling the public, modify, yeah, hard, ask your bank to help you. But you're telling me they already know. So how is the crook gonna let me have to go through all this trouble to prove something that they like a crackhead? You lost some money in the house, I stole it, I'll help you find it. This is pitiful for America.
Yes, it is.
And especially the poor people like us, we got affected the worst. The rich got so much richer, and we still, I'm tired. Everybody here tired of fighting for a house. Here they bringing in people from other countries and say, come on home, America's not like that. But yet, we as Americans, we didn't get our 40 acres and a mule, and they taking the little house out and worked hard for, 3 of them. Plus, there was no programs for 3. I went to NACA, spent my time sitting there through all them hours, and then they tell me if you got more than 1 property, you don't qualify. I'm like, oh my God, I don't qualify for nothing but to get taken, my house to get taken.
And see, one thing about now, I didn't even go with everybody about one thing. I want because of everybody goes to work, they didn't want to see my name or somebody working as me, they literally kick me out the building. You know, and because of what I'm going to say, because I'm make sure when I'm talking, I talk long enough for their guests to hear what I'm saying. Because I tell them, see, the same way you walk in here, you're gonna walk out worse. And that shouldn't be, because when they had that one in Chicago State, I was sitting there. 300 people showed up that day. Out of 300 people, they only waited on 75. I was walking to my car, and this girl, she was in tears so bad. Her husband literally had to pick up and carry her to the car. You know, and my heart just went out for her because I knew what time of day it was. They even sick to put a spy on me. When I'm sitting up there waiting on spots, you know, and I knew what she was. So I told her, I say, every time I would say something to the client, I say, did you get that? You sure you got that? Oh no, Mr. I say, I just want to make sure you get that. So at the end of this section, you can run back over there and tell homeboy over there that you got everything down and I was not trying to steal this client. Because I already know he put you over here. No, Mr. That wasn't it. I said, well, I'm the only one that you came to set the table with. You know, see, one thing I do, I watch everything go around me. Yes, ma'am.
I do appreciate this information. Two things. If you modify your loan, can you still go after them? Because I definitely want to go after Bank of America. Okay.
It doesn't matter if you're already into a modification already. Because the fact is, wait a minute, you don't put me into this modification. 9 out of 10, you probably got deferred payment, which they put that deferred payment at the back of the loan. So they gave you 30 years, 2%, then it went on through the times, and now you